In this video, we're going to talk about the important contract law case of Central London Property against High Trees House, which talks about the principle of promissory estoppel. In this case, the tenant from 1937 was leasing a block of flats from the landlord. However, when the Second World War broke out, the tenant had approached the landlord to request that the rent be lowered, as the tenant was having difficulties finding subtenants. The landlord agreed. So as you can see, the tenant was in the business of leasing out accommodation as an agent. After the war, by early 1945, the building had returned to full occupancy. When the landlord realized this and had a look back at the lease, he found out that the lease still had the full rent rate written on it. The landlord therefore demanded that the tenant pay the difference between the original rent rate and the discounted rent rate from the period. The tenant obviously tried to refuse, but the landlord was adamant. Now, the biggest obstacle faced by the tenant was that the promise to lower the rent had not been reciprocated with adequate consideration. In fact, it was not reciprocated by any consideration, and it did not specify for how long the lower rent would last. The only binding agreement, therefore, was the lease, which had the full and original rent rate on it. To test its claim, the landlord brought a test claim against the rent payable between early 1945 to late 1945. If the test claim succeeded, the landlord's plan was obviously to bring a second claim to recover the rent payable for the entire period between 1940 to 1945. In the case, Lord Denning stated that the rents due in late 1945 were in fact payable at the full rate, because at that point the war had ended and the flats were fully let. So this was obviously a detriment to the tenant. The reasoning that Lord Denning gave was that the promise was understood by all parties only to apply under the conditions prevailing at the time when it was made, namely when the flats were only partially let, and that it did not extend any further than that. When the flats became fully let in early 1945, the reduction ceased to apply. However, Lord Denning had anticipated the landlord's claims and stated obiter that with regards to the rent between 1940 and 1945, the landlord's promise to lower the rent was indeed binding, and therefore the landlord could not claim the difference between the discount rate and the original rate during this period during the war. And this was because of the doctrine of promissory estoppel, which his lordship summarized as having to do with a promise intended to be binding, intended to be acted on, and in fact acted on, is binding so far as its terms properly apply. In this case, the promise to lower the rent had been intended to be binding by the landlord and also the tenant, and in reliance on that, the tenant went about its usual business. So it would be inequitable for the landlord to renege on their promise, even if that promise was not backed up by full or adequate consideration.